Good afternoon, everyone. Welcome to our live webinar that is presented in conjunction by Gowling WLG and Akerman on Cuba policy under the Trump administration, extraterritorial implications. Very quickly, by way of background, since the 1960s, as we all know, and as we're going to hear in the presentation today, the U.S. imposed an embargo on Cuba. The provisions of this embargo have evolved over time and eventually resulted in the imposition of extraterritorial measures that affected Canadian companies. The Canadian government responded by creating the 1992 blocking order under the Foreign Extraterritorial Measures Act that prohibited Canadian companies from complying with the U.S. requirements. In 1996, what is known as the Helms-Burton Act was enacted, and such legislation included a very controversial provision, Title III, which allows U.S. nationals to take action against a foreign entity when the foreign entity is benefiting from United States property expropriated by the Cuban government. Given that the scope of Title III has virtually unlimited application to foreign business operations, the U.S. government has suspended its applications since inception, but we're now in a new era, and there is indication that Washington is preparing to very soon activate Title III. So to help us understand the effects of Title III and its implications for the Canadian businesses, we have a highly qualified panel of experts from both law firms. Gowling WLG, a Canadian international law firm with over 1,500 professionals in 19 cities around the world, and Akerman is an American law firm with more than 700 lawyers and business professionals across 24 offices in the U.S. Our first speaker is Matthew Aho. He's going to be speaking about Cuba policy making and the interplay between the key players. Matthew Aho is a special advisor on Cuba at Akerman's offices in New York. Matthew was involved in Cuba policy formulation during President Barack Obama's first term and joined Akerman in 2012 to help American companies develop strategies for the Cuban market. Since 2014, Matthew has successfully developed market entry strategies for a wide range of clients, such as Airbnb, Orbis, and Expedia, and advised on marquee deals, such as Major League Baseball's recently announced agreement with the Cuban Baseball Federation. I'll pass it now on to Matthew.
Thank you, France, and thank you to everyone from Gowlings for the opportunity to talk with you today. I know that the topic of today's webinar focuses on the specific issue of Title III, but I thought it would be helpful to take a quick step back and provide a little context about Cuba policy under the Trump administration and how that fits into the United States' historic approach to the island. For the past 60 years, essentially, the explicit goal of U.S. policy when it comes to Cuba has been to promote regime change on the island, a change away from the Castro government and towards something with freer markets and democracy. And to that end, the United States has maintained a comprehensive set of sanctions on Cuba, the goal of which is to deny resources to the Cuban government with the hope of destabilizing the regime. Unlike in other cases where the U.S. has decided to sanction a particular country or individual or industry sector, the Cuba sanctions are blanket sanctions. They prohibit all transactions by all Americans with all Cuban persons anywhere in the world. The starting point really is, as they would say in Spanish, nada. You can't do anything. However, understanding that having no commerce and no transactions whatsoever isn't realistic, the embargo does provide some policy flexibility to the executive branch, the president, who retains the power through his or her control over the federal bureaucracy and the agencies that administer and enforce the embargo to authorize certain types of activities through the issuance of licenses. And so to avoid confusion, I'm just going to go through a few of the different parts of the U.S. government that actually enforce and administer the embargo. The first one is the Office of Foreign Assets Control, which is housed within the U.S. Treasury Department, and they maintain federal regulations called the Cuban Assets Control Regulations. those are essentially the bulk of what we commonly refer to as the embargo. However, the United States Commerce Department, through its Bureau of Industry and Security, also administers certain regulations pertaining to the physical movement of goods from the United States to Cuba. And so there are export restrictions, and those are maintained by the Commerce Department. All of this is supposed to be handled in coordination with the U.S. Department of State, which is supposed to provide guidance to OFAC and the Bureau of Industry and Security about questions that arise and whether those questions and how to answer those questions in a way that's consistent with U.S. foreign policy goals. Lastly, the White House National Security Council at times has gotten involved in its role as a coordinating body within the White House between those agencies. A quick note on the Helms-Burton Law, with the full title of which is the Cuban Liberty and Democratic Solidarity Act of 1996. We're going to be talking about Title III, but it is important to note that it was the signing of Helms-Burton in 1996 that created a lot of the statutory restrictions and codification of the embargo at large, which Pedro is going to talk about. So the reason why a president can't go and just lift the embargo by himself through executive action is precisely because of the codification through Helms-Burton. So I'm going to walk you real fast through the last several years of Cuba policy in the United States and kind of how we got to where we are. You'll all probably remember the historic announcement in December of 2014 when Barack Obama and Raul Castro held simultaneous press conferences announcing their decision to normalize the relationship between the two countries. That was followed in July of 2015 with the opening of embassies in Havana and in Washington for the two counterparts. Of course, there was in March of 2016 the historic visit by President Obama to Havana. He was the first president actually since Calvin Coolidge in 1928 to go to the island. And quickly thereafter, the reestablishment of regularly scheduled U.S. flights to Cuba, not just limited to Miami, by the way. There are flights out of Miami, Tampa, Charlotte, North Carolina, New York City, and others. And cruise line service primarily through South Florida, which has become the biggest source, the biggest news source of U.S. origin traveler arrivals to Cuba since cruises were recommenced in 2016. In November, of course, of 2016, the presidential elections yielded an unexpected outcome, and for those of us in the United States who watch Cuba policy, there were a lot of question marks. President Trump, during much of his career, is a hotel real estate developer, and he had actually sent people down to Cuba to scout potential opportunities. And so there were some people who felt, well, wait a minute, this guy probably just wants to do deals, and we shouldn't worry too much about him messing with the policy. He had even acknowledged in numerous news interviews that he was basically okay with Barack Obama's policies regarding Cuba, but of course he would have got a better deal. That quickly changed in October of 2016 when he pivoted in South Florida to a much more conservative and traditional Republican position vis-a-vis Cuba, and announced that he would move to reimpose sanctions to end the period of normalization and to do everything within his power to hasten the end of the Castro government. That policy took form in June of 2017 when Trump gave a speech in Miami and issued what's called a National Security Presidential Memorandum, which is how the White House communicates its directives to the federal agencies. And within that National Security Presidential Memorandum, or NSPM, he outlined a variety of changes that were designed to further sanction Cuba. Those changes were enacted through OFAC and BIS, the agencies that I mentioned before, in November of 2017. And a year later, we start to hear a lot of different feedback and a lot of different rumors about revisiting the infamous Title III of Helms-Burton. A quick note on Trump foreign policy vis-a-vis Cuba and its relationship to the normal way of doing foreign policy in the United States. Few things. Number one, the sidelining of the U.S. State Department's traditional role in foreign policy formulation. Since the founding of our republic in the 18th century, the State Department's role has been to handle relations with foreign governments. It still exists. We have that role, but in historic context, the State Department is playing a more diminutive role than it has traditionally played. It has given way, in large part, to the rise of a very muscular National Security Council at the White House. The NSC, as it's called, is really designed to be coordinating foreign policy at different parts of the federal bureaucracy. It's not typically a policy formulation outfit, but we are very much seeing policy being formulated and driven out of the NSC under the Trump administration. And key positions at the National Security Council are occupied by people with long-held views, Cuba policy views that I would describe as hawkish and very conservative. Lastly, we have Senator Marco Rubio from Florida, who is very vocal on Cuba. He's very vocal on Venezuela and Latin America issues in general, but Cuba is his main focus. He is very much in line with conservative South Florida Cuban American thinking on Cuba policy, and has been very vocal on the issue. There's an anecdote that when the National Security Council first asked President Trump what he wanted to do on Cuba, he said, "Oh, go make Marco Rubio happy on it." So we've seen a very heavy influence coming from him. That, of course, is important because Cuba is, more than anything in the United States, a domestic electoral campaign-related issue, given Florida's prominence as the most important swing state in presidential elections. And so a lot of this policy, I believe, is being driven by a desire to please a key constituency in South Florida more than it is traditional foreign policy or international relations thinking as they would apply to other countries. The last thing I'll note, and this is not inconsequential for, I think, our Canadian audience, and therefore I'll use Canadian terminology, is the idea within the National Security Council of a hat trick in Latin America. Basically the end of left-wing governments in Venezuela, Cuba, and Nicaragua as being the sort of end goal of some of the neoconservatives that occupy important policy positions at NSC. So that's the rosy picture of my view of how foreign policy is being formulated in the Trump administration. A quick word on Title III, and I will not dwell on it because we're going to hear from people who are more experienced than I am on the topic. But it really has been the ticking time bomb in U.S.-Cuba relations for a long time. It purports to be a mechanism for helping claimants, property claimants, to seek recompense for confiscated property, but its real goal is to discourage foreign investment to Cuba by creating new legal exposure for foreign companies who are, in the United States. The last thing I'll note is that Title III was so controversial in 1996 when it was passed that President Clinton insisted on an executive option to suspend the provision before signing Helms-Burton into law. And so that's why we've seen every 6 months since 1996, under both Republicans and Democrats, the U.S. president moved to suspend the provisions of Title III. What companies should do to prepare? Very quickly. Number one is encourage their governments and trade associations to raise Title III concerns in bilateral talks with the United States. We can talk more about that, but the NSC is a good target. Number two, identify potential exposure to Title III lawsuits if you are a company that has dealings in Cuba and property that may be subject to a Title III claim. The last one is to explore the second to last, explore possible countermeasures under international law. And then finally the last one is to consider legal challenge to Title III in the United States under jurisdictional or other grounds. There are ample grounds, I believe, to challenge the law. So I'll stop there. Hopefully Gregory has joined us from Havana and will be able to talk us through what the Cubans are thinking about all of this.
Thank you very much, Matthew. And before we get into the full analysis of Title III, sipping mojitos directly from Havana, we have Gregory Wieniawski. Gregory Wieniawski is a Canadian lawyer who has been living and working in Cuba for the past 20 years. And he's the Havana-based business consultant for Gowling WLG. Gregory is going to let us know how Havana is reacting to this potential activation of Title III. Gregory?
Yes, hello, France, and hi to everyone from sunny and warm Havana, Cuba. What I want to do very briefly is talk a little bit about what I've been hearing from Cuban officials, what I've been able to observe amongst the Cuban population with regards to this potential Title III implementation, what I've heard from foreign business community, and then foreign diplomats here, and then finally just very brief mention what other countries are doing in terms of potential blocking orders directed towards Title III. With regard to the Cuban government, they've had a historical and very energetic rejection of Helms-Burton, and this looming implementation of Title III in their minds is just part of the same story that's been going on since 1996. Of course, Title III is coming at a very bad time for the Cuban economy, so they're extra energetic with regards to the rejection of Title III. Now, one of the things that I've noticed the Cuban government constantly raises is they question this whole notion of confiscation versus nationalization, and this is, of course, a much more complex legal debate, but they insist that they offered compensation for those properties that were nationalized, and they raised many major Canadian and European companies were compensated during the first years of the revolution, and so they question the whole notion of whether there's arbitrary confiscation. They have, interestingly enough, placed a lot of coverage of Title III on Cuban media, on Cuban TV. I think they're preparing the Cuban population for what might be coming, and also the potential consequences of that being a more difficult economic time. And finally, the Cuban officials have said they're really hoping that there's going to be a vigorous response from U.S. trade partners such as Canada and the European Union. In terms of what I see on the ground and what I hear on the ground, Cubans across the board, whether they agree with the government or they don't, they definitely do not like the notion of Helms-Burton squeezing their economy, and the same goes with Title III. So there's a general popular rejection on the ground here that goes beyond politics. They're very fearful of how this is going to potentially impact the efforts by the Cuban government more recently with the Diaz-Canel administration to open the country further to foreign investment. With regards to foreign business people, again, they're very worried. Across the board, Canadian business people, European business people are very worried, and they're actively inquiring into what their own countries are doing with regards to protective blocking measures to respond to Title III. And one of the things that really strikes a lot of foreign business people is the vagueness of the terminology in Helms-Burton and how it could be used by Title III. I'm sure Pedro is going to talk a bit more about that, but a lot of these terms really, they're not sure how they're going to be interpreted in U.S. courts, and that worries them. In terms of, let me get to the next slide here. In terms of the foreign diplomats, there's a general silence, there's a wait-and-see attitude. One of the things that a Western European diplomat just recently told me is, just remember what the furor was in 1996 when we saw Title III for the first time, which led Clinton to suspend it. Well, that's what's going to be coming if they dare put in Title III. So we know what to expect from U.S. trading partners. And there's also a comment that this goes beyond Cuba, that this could set a very dangerous precedent for general trade relations between the United States and its commercial partners beyond Cuba. In terms of examples, I mean, Rick Dearden's going to talk about Canada's Foreign Extraterritorial Measures Act, but I can just say that a number of other jurisdictions have very similar blocking orders: the European Union, the United Kingdom, Mexico, and all of them have the basic elements that the Canadian blocking order has. Notification requirements, not to comply with extraterritorial reach, and specifically Title III, non-recognition, non-enforcement of any U.S. judgments, and clawback mechanisms that can help companies that have been affected by Title III. So that, in a very small nutshell, is essentially what I've been observing on the ground in Cuba. And now I'll pass it back to Franz. Thank you.
Thank you, Gregory. We now are going to get into the specifics of Title III, which, as we've heard, is a very complex legislation. And for that, we have Pedro Freire, who was also last week sipping mojitos with Gregory in Havana. Pedro is a partner at Akerman in Miami and is chair of its international practice. He represents U.S. companies active in trade with Cuba and is ranked by Chambers as a Cuban expert. He's also an adjunct professor at Columbia University Law School and the University of Miami, where he teaches a seminar entitled Cuba, Law, Policy, and Transition. Pedro, back to you.
Franz, thank you very much, and thank you to Gowlings for organizing this seminar. It's always a pleasure to be talking to our Canadian friends and sharing some concerning issues that involve all of us. And I first want to start by reinforcing something that Franz said at the beginning, which is the Helms-Burton legislation is very complex. It has a lot of moving parts. It has a lot of terms of art and interrelationship with other U.S. laws and regulations. So it bears careful scrutiny. And I didn't want to get too deeply into the weeds in this presentation, but I'm going to try to give what I think are the salient points and the actionable items for Canadian parties that may be interested in this. And the first thing I want to do, again, without getting too deeply into the detail, but I think it's important to follow up on Matt's introduction on how the U.S. embargo is structured, the architecture of the embargo, if you will. And it all stems back from a 1917 law called the Trading with the Enemy Act, which empowers the President of the United States to authorize regulation, financial and otherwise, to basically put a damper on the activities of an enemy of the United States and their ability to use financial resources associated with the United States. The other basis for the embargo, the Foreign Aid Act of the early 60s. And then by the early 90s, there was more activism on the part of the Cuban American community in Washington, and there was another act called the Cuban Democracy Act, also known as the Torricelli Law, which restricted the ability of U.S. companies with foreign subsidiaries to trade with Cuba. But the key act that concerns us today is the Helms-Burton Law. The formal title is the Cuban Liberty and Solidarity Act. You see the legal citation there. And it's important to understand the context under which this law was enacted, and I'll get to that in a moment. The other two items to remember are the Cuban Assets Control Regulation, which are administered by the Office of Foreign Assets Control of the U.S. government. And these regulations interpret the law, and they are subject to change by presidential directive and influence and so forth. So please keep that in mind, that not only is Title III in the offing, but changes to the Cuban Assets Control Regulation, which basically govern everything having to do with the embargo, are also likely to be enacted and have already been changed by the Trump administration as a result of the change in policy that you heard about. So there's more to come in that arena, and that's on the regulatory arena. And finally, there's the Export Administration Regulations, and the way to understand that is the trade aspect of the embargo. Those are the regulations that authorize or don't authorize the sale of products to Cuba. For example, under those regulations, the sale of food items is usually authorized. The sale of pharmaceutical items is usually authorized, but there's a process behind that. The next thing I want to address is how this law came to be. And we have to go back to 1996 and what is a very famous or infamous incident in international waters in the Florida Straits, where 2 U.S. registered aircraft with 4 U.S. nationals on board were shot down by the Cuban Air Force over international waters after they engaged in propaganda activities in the economic exclusion zone of Cuba, and sometimes they strayed into Cuban airspace, but not on the day they were shot down. And as a result of that, there was this sense of outrage. It's interesting to note that at the time this happened, the Clinton administration was moving rapidly to engage Cuba in a process that later was carried forth by the Obama administration, and President Clinton reversed course on the happening of this event. So what that law basically did, if you would, is hardwire the U.S. embargo. Because up until that time, the provisions of the embargo were the provisions enacted under the Cuban Assets Control Regulations by the Treasury under the authority of the Trading with the Enemy Act. What this law did is, if you would, it took a snapshot of the way the embargo looked at that point in time and basically said, this is now the law of the land. So what used to be regulation under another statute became a freestanding law. And the corollary to that is that in order to lift the embargo, which is something many people have been trying to do for many years, it requires congressional action, or it requires compliance with the conditions of the law, which we will talk about in a moment. And basically, it also prohibited financing of transactions involving confiscated property subject to a claim by a U.S. person as of March 12, 1996. And it also noted that the Code of Federal Regulations, the Cuban Assets Control Regulations, prohibited dealings in merchandise of Cuban origin, merchandise that has been transported through Cuba, or which is made in whole or in part from an article which is grown, produced, or manufactured in Cuba. So once again, you see a hardening, if you will, of U.S. provisions against the Cuban regime by the enactment of a very comprehensive law. Moving now to the core of what concerns us today, let me talk about a couple of key definitions in the law. And the first one is, who is a U.S. national? And a U.S. national under the purview of the law is any United States citizen, that is a physical person, or any other legal entity organized under the laws of the United States. And the importance of that definition and the implications of that definition is that people such as myself, who were born in Cuba but are now naturalized U.S. citizens, are by definition covered by the law. And as we will see in a little bit, the types of claims that can be brought are divided into two very well-defined categories. One is certified U.S. claims, which belong to U.S. citizens who were citizens at the time that the property was confiscated, and those properties are listed in the Federal Register and went through a process of certification, or non-certified claims such as those that can be brought by Cuban Americans who were not Americans at the time the property was confiscated. In terms of what is actionable under the statute, the definition is, to say the least, quite broad. And let's just walk through the language if we have a minute. The definition of trafficking, and that term was used with full intent because trafficking connotes drug use or an illicit activity and so forth. A person traffics in confiscated property if that person knowingly, that has to be the knowing element, sells, transfers, distributes, dispenses, brokers, manages, or otherwise disposes, purchases, leases, receives, possesses, obtains control of, or otherwise acquires direct or indirect control of a confiscated property. Let's stop there for a moment. This is basically a shopping list of every activity that you can conceive of in relation to a confiscated property that would result in some sort of financial benefit for the person engaging in that activity. And the importance of that broad definition is that folks who are active in Cuba and in any way, shape, or form derive benefit or touch a confiscated U.S. property need to be aware that they are very likely to be caught in the definition of trafficking. And recently I was reading an article out of Spain where a layperson was interpreting Helms-Burton and basically said, we have no risk because the risk follows ownership of the property, and we don't own the property, we manage it. That is a fundamental error in analysis because the definition itself says very clearly that included in the concept of trafficking is the concept of managing a property, which is what many, for example, hotel owners and operators do in Cuba through joint ventures and so forth. Now, the term trafficking has some interesting carve-outs, and let's understand that what happens here is that by definition, certain activities are not considered trafficking. And what would those activities be? Well, the term trafficking does not include the delivery of international telecommunication signals to Cuba, the trading or holding of securities publicly traded or held, unless the trading is with or by a person determined by the Secretary of Treasury to be a specially designated national. I won't dive down that particular rabbit hole. That's a different technical problem. And number three, I want to call attention to this one. Transactions and uses of property incident to lawful travel to Cuba to the extent that such transactions and uses of property are necessary to the conduct of such travel. And let's use an example there. And let's talk about, I'm not going to get into the ports. People are always wondering why not. I represent 5 cruise lines, so obviously I am precluded to go very deeply into all of this for reasons of privilege. But let's talk about, as a hypothetical example, the runway at Jose Marti International Airport. Let us suppose, hypothetically, that that runway belonged to a private entity, a private American entity. And let us suppose that that entity is now considering bringing an action against American Airlines, who is not my client, because they're using that runway. Under the black letter law that we see in the statute, that activity by American Airlines, i.e. landing in the runway, would not be deemed to be trafficking because that activity, in my reading, is an activity that uses the property as is necessary to the conduct of lawful travel. So there's an enormous carve-out, if you will, for property used by persons in conjunction with lawful travel. Let me tell you one concern I would have if I were a Canadian. I think that the position that the U.S. courts are likely to take is that this pertains to the use of that property by American companies engaged in authorized travel. I wonder whether they will read the statute broadly enough to say that it also includes the use by Canadian entities. So, for example, query, if Air Canada were to use the runway at Jose Marti International Airport, would Air Canada be excluded from the definition of trafficking? It is unclear. Finally, transactions and uses of property by a person who is both a citizen of Cuba and a resident of Cuba and who is not an official of the Cuban government or the ruling political party in Cuba. So that allows basically intra-Cuban transactions not to be deemed to be trafficking. Other definitions that are important are property, and here it says that property including intellectual property such as patents, copyrights, trademarks, and other form of intellectual property, whether real, personal, or mixed, and any present, future, or contingent right, security, or other interest therein, including any leasehold interest, is deemed to be property. Now, what is not included, and this one goes to the heart of many Cuban-American issues, and my family had a beautiful compound in Miramar, and Greg can go look it up, Séptima Avenida 30 y 32, there were 4 family houses. But for purposes of Title III of the Act, the term property does not include real property used for residential property unless, as of the date of the enactment of the Act, the claim to the property is held by a U.S. national and the claim has been certified under Title V of the International Claims Settlement Act of 1949. Those are the certified U.S. claims, or the property is occupied by an official of the Cuban government or the ruling political party in Cuba. So let's just parse that out for a moment. If a residential property, as of the date of the enactment of the Act back in 1996, is subject to a claim, a certified claim from a U.S. national, i.e. it was the home of an American citizen who was an American citizen at that time, then it's subject to a claim. Or if the property is occupied by an official of the Cuban government and the ruling political party in Cuba. Good question, because that beautiful property in Miramar used to be occupied by none other than Fidel Castro's older brother who passed away. So he's no longer occupying it. Query, is the Freire family entitled to a claim or not? To be continued. So, in order to protect the property rights of U.S. nationals, the law says that any person who traffics in property which was confiscated by the Cuban government or on after January 1959, that's the bright date in which Fidel rolled into Havana in a tank, shall be liable to any U.S. national who owns the claim to such property for money damages in an amount equal to the greater of the amount certified in the Claims Settlement Commission under 22 USCA, that's the process that we spoke about, or the fair market value of the property, and court and reasonable attorney's fee, if the claimant provides notice to a person against whom the action is to be started at least 30 days in advance of the case, and the person continues to traffic, then they would be entitled to treble damages. And this action may be suspended for a period of 6 months by the President of the United States. So parsing that out, the amount of the claim, if you have a certified U.S. claim, is the amount that was determined by that process of the Foreign Claims Settlement Commission back in the early 60s. And by the way, if you're interested in seeing who holds the claims, go to the web and click on Certified Cuban Claims, and you will be put into the section that lists all these claims, and you will see it in detail. They now total something in the order of $8 billion. So the claimant would have to notify in advance, and if the action continues, then it would be entitled to treble damages, but the President may suspend, and the President suspended, but they did not suspend for 6 months, they suspended for 45 days, and we're expecting an announcement March 1st. I believe I am running out of time, so let me quickly move to the next section. And there, what I will say in shorthand is that as evidence of ownership, proving up your claim, if you would, certified claims have the presumption of correctness for the amount that was certified by the Foreign Claims Settlement Commission, so you don't have to go through the difficult process of proving up your claim, whereas the others are required to be proven up and may be subject to the decisions of a special master in equity. I will skip over the rule of construction because I think that's a little bit of a technicality, and we're running a little bit short of time. And the other thing that is important to note is that if you are a U.S. claimant that could have had access to the remedy under the Foreign Claims Settlement Act and you did not avail yourself of your remedy, then you're precluded from pursuing that remedy at this point. And that's important because some U.S. citizens will be left out of the process due to that. Final point I wanted to make is that the law itself says that the act of state doctrine, which is a highly recognized concept of international law, where the actions of another government will not be subject to legal action in another country, is obviated, and it specifically says so in the law. So that defense cannot be presented by someone subject to one of these claims. Finally, I will wrap up by saying that there is also under Title IV, which is currently in effect, the ability for the Secretary of State of the United States to deny visas to any alien, any individual who is actually conducting that activity. And I will close by saying that one of the two instances where that was applied was against officials of Sherritt, the Canadian mining company. And with that, I will close my presentation. Thank you.
Thank you very much, Pedro. You really walk us through what it is an extremely complicated legislation and made it almost sound simple. Thank you. We now are going to hear how Canada struck back, as mentioned before. In 1992, Canada enacted what is called the anti-blocking legislation. To talk about that, we have Rick Dearden. He's a fellow of the American College of Trial Lawyers, and he's a senior litigation partner at Gowling WLG's Ottawa's office. Rick practices international trade law, and he acted for the government of Mexico as one of its external counsel during the negotiation and implementation of NAFTA. Rick provides advice to clients on Canada's Foreign Extraterritorial Measures Act, also known as FEMA, and he's going to talk to us about that. Rick.
Thank you, France. Good afternoon, everybody, from minus 28 wind-chilled Ottawa, where no one's drinking mojitos or sipping them. I'm going to be dealing with four matters. First, the Canada-Cuba relations, and then the Foreign Extraterritorial Measures Act, which legislates the non-enforceability in Canada of Title III Helms-Burton judgments. Thirdly, the powers of the Attorney General of Canada to issue an order declaring a Canadian can seek to recover damages and expenses in respect of a Title III judgment. And then lastly, to remind you of the obligations under Canada's Foreign Extraterritorial Measures United States order. Now, bilateral relations between Canada and Cuba are essentially the polar opposite of U.S.-Cuba relations today. Cuba is a major export market for Canada, and Canada is Cuba's fourth largest trading partner. The Cuban government is interested in the negotiation of a bilateral agreement on reciprocal promotion and protection of investments. That investment treaty negotiation has not launched yet, but Canada's interested in it, Cuba's interested in it, so hopefully something will happen on that front. The ambassador to Canada, Josefina Vidal, recently stated that Cuba's relations with Canada are a priority for Cuba and expressed appreciation for Canada's vote at the UN General Assembly in favor of the Cuban draft resolution demanding the end of the U.S. blockade against Cuba. Now, I dare say that many of you didn't know the historical fact that is demonstrated by my next slide. Here you have Rosa Fay, the father, a Canadian bull, father of the Cuban milk cow herd. As the legend goes, this Canadian bull produced Cuba's renowned milk cow herd. That sale was apparently not appreciated by the U.S. government at the time. And here you're looking at a bronze sculpture of Rosa Fay, commissioned by a Canadian lawyer, Carrie Linde. But standing behind Rosa Fay is none other than our Gregory Biniowski, who you just heard from, who worked with the Cuban sculpture and the Cuban government to help make that statute in memory happen. So I'm sure many of you will remember that as the most important fact to take away from this webinar. Foreign Extraterritorial Measures Act. FEMA is blocking legislation designed to prohibit Canadians and corporations from complying with extraterritorial measures. So as you heard from Pedro, in 96, the Helms-Burton Act, as I call it, was enacted. Canada then amended FEMA to strike back at Title III of the Helms-Burton Act. And what did we do in that regard back in 1996? We passed a provision in the Act that said any judgment given under the Helms-Burton Act shall not be recognized or enforceable in any manner in Canada. So get your judgment somewhere in some court in the U.S., but you aren't enforcing it up in this country. In addition, the Attorney General has power to order non-production or disclosure of records to a foreign court, and that would include Title III proceedings, and has the power to prohibit a person from testifying before a foreign court, and that would include also giving a deposition that would be used in a Title III proceeding. A Canadian citizen, and that would be including a resident and a corporation, so a Canadian as I'm calling it in this slide, can apply to the Attorney General for an order declaring that the Canadian can sue in Canada for relief against a Title III judgment that's been awarded against that citizen, resident, or corporation. And that relief can take three forms. Any or all amounts that was obtained under the Title III judgment, all expenses incurred in the course of defending the Title III action down in the U.S., and all expenses incurred in instituting recovery proceedings in a Canadian court pursuant to these provisions of FEMA, which includes solicitor-client costs. So that's a scale that's almost full indemnity, not quite, but it's higher than the normal award of costs you would get in a Canadian court action. And the third area of relief is any loss or damages suffered by the Canadian by reason of the enforcement of the Title III judgment. Now, in addition, if there isn't final judgment, there's relief available as well. Canadian can ask the Attorney General to allow the Canadian to sue the person who instituted the Title III action to recover the expenses in defending the Title III proceedings, and then the expenses in bringing the Canadian action in Canada pursuant to FEMA with respect to that Title III action. Now, we also have the Foreign Extraterritorial Measures United States Order of 1992 and amended in 1996 in response to the Helms-Burton Act. And that order is aimed at counteracting any extraterritorial measure that's aimed at impeding trade between Canada and Cuba. And there's two important requirements of that order. There's a notification obligation and a compliance obligation. The notification obligation has 6 parts to triggering notifying the Attorney General. So first, any Canadian corporation and every director and officer of a Canadian corporation, so those people or entity. Secondly, must give notice to the Attorney General. 3, of any directive, instruction, intimation of policy or other communication. We call that the received communications. 4th element, relating to an extraterritorial measure of the United States. So that would be Helms-Burton, for instance. 5, in respect of trade between Canada and Cuba. And the 6th element is received from someone in a position to direct or influence the policies of the Canadian company. Now, those terms, as you can see, are about as broad as could possibly be. And if a Canadian corporation or the director or officer is a recipient of a received communication, then there is a requirement under this law, this order, to report the information that you see in the second bullet on this slide. Then you have the compliance obligation, which prohibits any Canadian corporation and its directors, officers, managers, and employees from complying with any U.S. legislation that seeks to prohibit, infringe, or otherwise influence trade between Canada and Cuba. And that prohibition applies to any act or omission constituting compliance with U.S. extraterritorial laws regarding Cuba, even if compliance with that measure or communication is not the only purpose of the act or omission. So it's not an excuse, it's not a defense that there's a valid business purpose for somehow backing out of doing a deal or exporting goods to Cuba or whatever it is that's not good enough. You're not supposed to abide by any directive or intimation of policy, etc., telling you to stop trading with Cuba. And note that requirement, unlike the notice requirement, also applies to managers or employees in a position of authority. So there could be situations where an American parent tells its U.S. subsidiary to not do something to ensure that there's no violation of Helms-Burton, or in respect to Title III specifically, to somehow get out from under a possible Title III action, and that would trigger the notification obligation, as well as I think it would not comply with Section 5 of the order. And the consequences, to wrap up, are serious. If charged by indictment, corporation faces a $1.5 million fine, and an individual $150,000, with a maximum imprisonment term of 5 years. So that's my presentation. Franz, over to you.
Thank you, Rick. Definitely not an easy question any side of the border, that's for sure. We have a few minutes for questions, and we have a number of questions submitted. For the listeners, please note that the slides will be circulated to everybody who registered following the presentation, and those questions that we don't manage to cover in the next few minutes will be answered for sure by email. Our first question, I believe, is Pedro or Matt. Do you believe that U.S. nationals can still register as foreign agents for Cuba? Or with the increasing severity of U.S. sanctions, do you think that the U.S. would deny such a registration?
That's a separate statute, and I think that's just a simple, straightforward requirement under U.S. law, that if what you're asking is a U.S. person who is acting as an agent of the Cuban government, that's just a technical requirement, and you have to do that if you're doing it. And it is completely separate from issues of U.S. policy requirements or U.S. policy implementations. You can be an agent of the North Korean government, or you can be an agent of the Iranian government. All you would need to do is register, and that's it.
The next question is, what risk would apply to Canadian, and they added here, or Mexican corporations involved in the online sale to U.S. individuals of tours or excursions organized in Cuba by Cuban suppliers?
Wow. That's an excellent question. And I think the risk there is the risk of what you don't know, because let's work with this on a hypothetical basis. If those tours touch upon or impinge upon confiscated property, if you don't know of it, then you can always, allege what I don't know, but there's an implicit duty for you to find out. So my first reaction is you better do some due diligence and find out where those tours are going, and if any of the tour destinations are in confiscated property, because I think that's where the exposure would come in.
So we have a few other questions. I think they will apply both Matthew and Rick. Is there anything Canada and Canadian companies can do to persuade the United States not to implement Title III?
This is Matt. I can speak to that. So the answer, I think, is yes. It's a challenge to be able to say definitively that it's that you or anyone is going to be able to persuade the administration not to allow the title to come into force. However, I would point to some significant geopolitical issues in Latin America that Canada and the United States have shared interests in, and I'm thinking, of course, of the situation in Venezuela. My best guess is that Venezuela is far more important to some of the people who are formulating policy at the White House right now than Cuba is. I think Canada's shared position with the United States on Venezuela is something that the U.S. values. And so I would say from a Canadian company perspective, you work through your contacts with the Canadian government, work through your trade association contacts, and make sure that your government is aware that Title III is something that you're concerned about, and ask them to raise it with the United States. And I think that Spain, Canada, and all of our allies can and should consider doing that in the coming weeks.
We have just one question that just came in. Would you be able to enforce a court decision regarding reimbursement of costs incurred to defend a Title III lawsuit against a Canadian subsidiary of a U.S. company? I believe. Right.
Yeah.
Is that for me, Franz?
I will think so.
I don't understand that question. Give it to me again.
Would you be able to enforce a court decision regarding reimbursement of costs incurred to defend a Title III lawsuit against a Canadian subsidiary of a U.S. company?
Well, enforce it in Canada. If that question is directed at the relief that a Canadian can obtain that has had a final judgment issued against them, then if there are assets that are available, I'll just speak for Canada, in Canada, then absolutely you can enforce that cost order or the damages order, just like any other proceeding.
Okay, we have a few more minutes. One more minute. I think we have time for maybe one more. How should the Canadian government react if the Trump administration decides to take action on Title III? I guess that's a very open question, but any thoughts? Again, I think it will be tied up to what Matthew was saying before.
Well, yeah, I think there's kind of before the fact and after the fact. And before the fact many of our clients, we're working here in the United States to communicate to U.S. officials at the White House, but also to members of Congress, that our clients are concerned about this issue and that it's important to them. And like I said, I think that there are avenues through your government and the governments of other companies that are involved in Cuba to push that. After the fact, I think that this will become a legal question. It may be possible in future at a future point to try to push for resuspension, but once the wheels get moving on the legal side, I think it can get a whole lot more complicated, and explore ways to challenge the title right out of the gates if in fact the administration pulls the trigger on this.
Thank you, Matthew. So we're at 12:59, and our webinar finishes at 1 p.m. I want to thank everybody and all our presenters. This was an excellent discussion. For all the listeners, both Gowling WLG and Akerman have very developed and fulsome practices relating to Cuba. We regularly partner to help our clients in their matters, relating to Cuba. So please feel free to contact anybody that is, you have all of the contact information on the slides. Feel free to contact them directly and to ask any questions. As I mentioned, there were a number of additional questions. We will be circulating those answers to those questions in writing together with the slides within the next week or so to everybody that registered. My name is Franz Tanai. I am the leader of the Cuba practice from Gowling WLG in Canada. Thank you, everybody, and thank you, the presenters. Have a good day.